Okay, we're back for session 2 on the protection of civilians in occupied territories. Please take a seat. I'm very pleased to have with us today the President of the Palestine Red Crescent Society, Dr. Yunis Al-Khatib, I'm really curious to listen to your presentation. You have the floor. Thank you very much.
Thank you very much. Ladies and gentlemen, good morning, everyone, or good afternoon. I have a written speech, but guess what? I have forgotten my glasses, my reading glasses. So, bear with me. Allow me first, can you use this? That's great, huh? But I can't see you well. Allow me first to express my gratitude to Webster University for its continuous interest in matters related to international humanitarian law and human rights. In doing so, it helps optimize the implementation of these legal instruments with a view to reducing human suffering and safeguarding rights in times of peace and war, including the rights of persons under military occupation. In more than 150 years of modern IHL, 120 years of the law of occupation, and 70 years of the Geneva Conventions of 1949, the protection these instruments offer remains insufficient despite having increased with time. Organizations tasked with monitoring and tracking the implementation of IHL, including the International Movement of the Red Cross and Red Crescent Societies, to which we belong, have failed in this regard. I'm talking about Palestinian situation, case, and maybe in the Middle East as well. So it might have been successful in other cases or areas. Moreover, contracting parties, i.e. all the countries in the world, have failed in meeting their legal obligations under Common Article 1 to the Geneva Conventions, which lays down an obligation to respect and ensure respect for the conventions. Human suffering as a result of armed conflict has increased over the past few decades and intensified in recent years. This is a repercussion of modern-day warfare fought by both conventional armies and non-state actors, often in populated areas. A wide array of violations is committed in armed conflicts and in occupied territories, qualifying sometimes as grave breaches and war crimes. These include targeting, clamping down on, starving and blockading civilians not taking any part in the hostilities, torturing or ill-treating detainees, captives, and prisoners of war, using prohibited weapons and technologies, causing unnecessary suffering, environmental pollution, and short or long-term health effects, mobilizing children and engaging them in armed conflict, wide-scale destruction of properties not imperatively demanded by the necessities of war, and targeting and obstruction of medical missions. In the Palestinian case, I feel eager to talk about this example. We have passed through, I don't know why this is going back and forth alone. It's working by itself, by the way. I think through human history, I'm not sure, but you can correct me. Something happens in the Palestinian situation that did not ever occur. When an occupied population has to witness international boycott or international siege, you are already occupied, and then the international community says we will boycott the occupied population. This happened in 2006, when the international community asked the Palestinians to conduct, under occupation, democratic elections. And we did have a democratic election as part of democratization of the Palestinian community or society. And when the result did not like the international community, a decision, regardless of what the result was, the international community took a decision to boycott and siege the Palestinians, who are already besieged by the occupation. In the occupied Palestinian territory, such violations are widely encountered. They constitute a breach of IHL, especially the Fourth Geneva Convention of 1949, relative to the protection of Palestinian civilian persons in time of war. This convention lays out a comprehensive framework for the protection of populations living in an occupied territory, considering them as protected persons. It also includes an array of political, economic, social, and cultural rights needed for a normal life and prohibits a number of measures and actions, some of which amount to war crimes. Globally, IHL sought to preserve the status quo of the occupied territory, prohibiting its complete or partial annexation, as well as the transfer of civilians of the occupying power in the occupied territory, and the looting of resources. These breaches are committed on a daily basis by the Israeli occupation authorities. Statements and resolutions by the international community condemning such practices abound at the UN General Assembly and Security Council, but effective measures are yet to be taken to constrain the occupying power. I hope I can go back. Not working. You know, I thought to make things clear and to make you have a sense of the field and how to live under an occupied land, I thought to show some photographs. I'll start with the one on the screen now. This is the wall, called the separation wall. Others call it the apartheid wall, which separates. The International Court said Israel can build anything in its own territory. But what happened that this wall, 85% of it is built on Palestinian territory, which meant it will separate Palestinians from each other. It meant a population on one side of the wall to go to its fields or agriculture, to farming. They will need to cross to the other side. If they need to go to their school, kids, and this happens. So the Israelis created gates for kids from 6 o'clock until 6:30 in the morning, where they can cross through these gates just to go to their schools. So this wall really, what it created a situation where Palestinians are separated from each other. This photo talks about detainees. When you talk about prisoners of war in Palestine or detainees, people might think these are persons detained as a result of armed conflict, or, as the Israelis say, terrorist acts. The reality is, most of these detained persons, prisoners, are just, could be young people, under 18, like this young lady or this young gentleman who has been detained during peaceful demonstrations. Through the occupation since 1967, over 1 million Palestinians has experienced a detention in one way or another. Now we have around 7,000 detainees in Israeli prisons. These photos just show the daily life of Palestinians. The picture in the top shows how Palestinians cross between cities, like if you want to go to Jerusalem or to go to Gaza, or as it was at the separation wall, you have to pass through tunnels like cattle from one place to the other. Demolition of homes, 2009 until 2019, the last 10 years, over 5,851 Palestinian homes have been demolished for different reasons. Some of those could be in Jerusalem, East Jerusalem, occupied in 1967, where Israelis say there is no licensing. But if you go into documentation, you'll find hardly Israelis give licensing for buildings since 1967 for Palestinians. While tens of thousands of settlements, as you see in the top photo, illegal movement of civilians, Israeli civilians, to the occupied territories. And this is one Palestinian home being demolished. As a national society and a member of the International Federation of the Red Cross and Red Crescent Societies, PRCS operates under extremely difficult conditions. It faces daily challenges as a result of measures and policies taken by occupation authorities. This undermines both its mission and humanitarian services. Numerous violations are committed against the society's medical missions, including attacks against its crews, vehicles, and facilities, as well as obstruction and denial of access to persons in need of urgent medical assistance. Tens of PRCS staff and volunteers working mainly with its emergency medical services have been killed, while hundreds others have been wounded. Also, I'd like to share some photos of our medical staff that we have lost or got injured at different times since 2000, when the second Intifada broke out. This is a photo of Dr. Khalil Salman, who was the director of our ambulance station in the north, in Jenin area. And this is the ambulance that he was in when it was attacked with a rocket, and he was killed, and it totally burned, with another two of his staff also severely burnt. During 2008, can we go back? We had 17 of our medical staff. And here I'm only talking about medical staff and volunteers of the Red Crescent. There are many others from different organizations and from the Ministry of Health who has lost their lives conducting their humanitarian duties. 17 of our medical staff and volunteers were killed between the year 2000 and 2006, which is the second intifada, and tens were injured. During the war, 2008-2009, also we have lost one of our EMTs, while I think the Palestinian health system lost about 15 medical staff. 57 were injured. This is one of our volunteers who was killed in that war. This is our hospital in Gaza that was bombed, and you can see the inferno, and there are 3 buildings there, one completely brought down, and the other 2 damaged, severely damaged. 22 of our ambulances were damaged. There should be a slide here about 2014 war, where we lost 2 of our medical EMTs in the war, and several of our institutions, medical institutions, were hit and damaged. In Jerusalem, also, between October 2015 and March 2016, when the Israelis tried to create new controls over movement and worshiping in Jerusalem, created some violence. This shows part of it. When the Israeli army used this pepper gas or type of a gas against medical people. Actually, this photo, the target was the journalists, the press people, and when our people tried to get one injured, they also attacked them with this gas. These are numbers of different violations in 2018. Also, denial of our ambulances to move sick people into hospitals, especially to Jerusalem. Jerusalem is the center where most of the referral Palestinian hospitals exist. Some of these denials have witnessed birth of kids, of children, of babies at the checkpoints because the ladies were not able to reach the hospital. So our staff do face daily violations against medical missions, whether in the West Bank, where people think it is a bit relaxed, or in Gaza, where it is violent. Last night in Gaza, there was a kid killed, 15 years old. You know what's happening with these demonstrations in Gaza, at the borders of Gaza, what they call the Great March of Return. They are not any more violent, I think, than the French Yellow Vest demonstrations in Paris. But why 250 civilians or 55 civilians till now have to die? Because they're going out in peaceful demonstrations. I will conclude in this regard. A legal and moral duty falls on international community represented by the UN General Assembly and Security Council, state parties to the Geneva Convention, both individually and collectively, as well as international humanitarian organizations, including the International Movement of the Red Cross and Red Crescent, need to review their methodologies and response to this situation to ensure they play an active role in providing protection and strengthening legal frameworks and tools needed for the full implementation of IHL I think Switzerland and ICRC should not give up on compliance of IHL and should continue their efforts. We should not accept failure because there is a need, really, to force those parties to conflicts to comply with IHL. Thank you very much.
Thank you, Dr. Al-Khatib, for your testimony also of what's happening these days in Palestine. Now we give the floor to Lama Jbara, if the pronunciation is correct, and she will talk about the interaction between IHL and international human rights law, the protection of civilians in occupied territories. Lama is a teaching assistant human rights law at Webster and also the vice president of internationallawyers.org here in Geneva. The floor is yours. Thank you.
Thank you very much. And thank you for being here, all of you. So we're going to remain in the occupied Palestinian territories. However, my presentation is going to focus on the importance of the interaction between international humanitarian law and international human rights law in the occupied territories, and specifically for the protection of civilians over there. So we have heard from the previous speakers about the gaps in both laws, and here the focus is going to be about the how those laws complement each other in terms of protecting the civilians, especially in occupied territories. So I chose here the previous slide. Yeah. Okay, so the next slide. I chose here a case study to simplify things for you because things could be a lot complicated when we speak about this interaction and interplay between both bodies of international law. So this case study is about an area in the city of Hebron. The city of Hebron lies in the West Bank in the occupied Palestinian territories, and it is the biggest, largest city in the West Bank. So this area, specific area, which is referred to as Area H2, and the part of the old town is there. It has a very religious importance to the Jews and Muslims. So it is a city of religious value. And it is under effective control of the Israeli army. So this area is inhabited by almost 40,000 Palestinian and some 400 Israeli settlers. And it's, there's about 4,000 soldiers are spread across the area there to control and provide security and protection for the civilians living under the occupying power jurisdiction. So there has been various reports coming from different monitoring bodies at the regional, local levels, from NGOs, from the committee, Red Crescent Committee, from the ICRC, from also the international presence, because there is a international temporary presence over there. There is a civilian mission is stationed there with personnel coming from different European countries to monitor the violations that are taking place there when it concerns human rights law and humanitarian law. And these reports on the Human Rights Council level, on the Security Council level, and on the regional mechanisms, the treaty bodies, committees, saying that or stating that Israel is committing violations under both laws, and there is a systematic ignorance of its obligations under international humanitarian law and human rights law, and also Israel is not bound by the treaties that it is party to and Israel is party to most of the human rights treaties. Let's take what is the situation over there. The situation over there, in a nutshell, there are, in 2015, this area was, Israel made it a closed military zone. There is a intense restriction of the movement of the Palestinian civilians over there. The infrastructure has been changed in order to create that separation between the Palestinians, and the civilian Palestinians, and the Israeli settlers. There would be no kind of clashes between them. And this change to the infrastructure resulted in the change of the status quo of the land over there, which is also in violation of international law in some cases. And this, according to a lot of experts, is amount to the level of annexation rather than change of the infrastructure. There are also reports about the transfer of the civilians from Israel to that area. The settlers are coming there. The settlers they have license to carry guns and rifles, and the Israeli forces are reported to be passive in dealing with them, watching the violations they're taking place over there. There is the reports about denying the Muslims from going to the mosque. There is a mosque over there of religious importance to the Muslims, so they're not free to practice their freedom of religion. There have been detention for children underage and without due process, putting them in detention facilities. Reports about arbitrary killing, which is prohibited under both international humanitarian law and human rights law. So where the interaction here comes into play, how is it important and how it protects the civilians? I also gonna bring some incidents that occurred over there, and it's still occurring, but it will explain and somehow how this interaction is very important for protecting the civilians, especially in cases where there's a prolonged occupation. So the occupation usually is an international armed conflict. However, it has a specific property, which is the occupation, especially lengthy occupations. It is positioned in a period where the situation is relatively calm. So it's not a war zone. It's not so the overall atmosphere is calmness over there. So you have a case study, you have a situation which the armies are confronted with on constant basis, where there is an allegation of someone who's planning to carry out terrorist attack, carrying a knife, trying to threaten the security of the military over there. So here what happens under international humanitarian law, in times of hostilities, when the hostilities break out, it's not unlawful to kill a person who's participating in a combat or who's taking a direct act in hostilities. However, the arbitrary deprivation of life under international humanitarian law is prohibited, and there are regulations under the Hague Regulations, the Geneva Conventions. They actually put rules for the soldiers and the command-in-chief in order to verify before killing a person. However, in a situation like this, you have a situation where most experts, and there is consensus actually that the situation under effective control, and one case wouldn't provoke chaos. It's not an intifada. There is no breakout of hostilities there. So the vision of the soldier is not blurred, not to see if this person is carrying a rifle or participating in direct hostilities. So under international human rights law, the right to life is a peremptory norm. So it's non-derogable. There's no derogation for this. So the killing of a person should not be. The international human rights law encourages or it embraces the law enforcement method, which urges a state or an occupying power to arrest or detain the person before, before resorting to any kind of lethal force. So the problem is with the interpretation of some jurisdictions. That's what we have. For example, the ICJ, the International Court of Justice, in its advisory opinion on the use of nuclear weapons, it held that whenever there is a simultaneity of application of both laws, which is the situation here, the overriding rule, or the lex specialis, what we call, is the law that prevails, which is international humanitarian law. So some states and occupying powers, of course, serving political interest and serving their interest, they held that the international humanitarian law is the law that is applicable for granted. However, given a situation like this, where there's calmness. So here, this oversimplifies actually the situation in practice when you want to apply both laws. So you have the element of duration, you have the element of the jurisdiction, the interpretation of states that comes into play. But how do both laws complement each other in such situation? So you have a monitoring body on the ground. Those monitoring body, NGOs, the international prisons, reporting, the Committee of the Red Crescent, the Red Cross, they're all working together to report these cases to the highest level, to the international level. And the international level, it reached the point where it exerted some kind of pressure on the State of Israel to change its approach, especially towards the targeted killing, what we call targeted killing. And this affected their policies to a certain extent. It's still going on, but not in this area. Maybe there are other areas where there is a breakout of hostilities that it is applicable. And so it changed somehow its approach towards dealing with such cases, especially at checkpoints, which this area is fortified with checkpoints and razor wires everywhere. So it resorted to the law enforcement mechanism, which is encouraged by international human rights law, and which urges the detention of the people. So the second situation where you can see the importance of this interplay is the detention of suspects. The reports came that Israel conducts some kind of what is called the security detention, internment, or the administrative detention, which is detaining people without having legal basis for their detention, based on the suspicions only, and they're actually deny them the right to have lawyers. They put them in detention for without due process, without the right to having the right to a free trial. Under international humanitarian law, detention is possible for future suspect, for someone who's planning to carry out an attack, a future attack. However, it should be in conjunction with international or human rights law. So this is the division of the international human rights law with the Hague Regulation and Geneva Conventions. But for international human rights law, it provides a blanket of protection which is more extensive. So when you place these detainees in prison, you have the committees on the ground from the Red Cross and Red Cross visiting them, but you have the human rights lawyers and advocates. They urge the detainees. There are obligations under international human rights law to let these detainees know what their charges are, why they're taken to prison, to provide them with the right to have a lawyer. So here, in such cases of occupation, the human rights law puts emphasis and complements the role that IHL is playing in that term. But however, I'm not, I'm inclined more towards human rights because I work in the field of human rights, but I cannot underestimate the role of international humanitarian law. And you have also caveats in the system of you have flaws in the system of human rights law, where the treaties provide the possibility of derogation in certain cases. So under, for example, the International Covenant for Civil and Political Rights, you have the possibility to derogate under one provision, the possibility that a state could derogate from certain rights in cases of emergencies or situations where it threatens the life of the nation. There's a threat to the life of the nation. However, as well, in practice, and with the gathering of some experts, they came out to the conclusion, for example, that in such cases of prolonged occupation, the derogation is not possible at all the time because it is actually you cannot just derogate from the right to have a free trial for a long time because there is a situation threatening the life of the nation. So here's the situation where it is relatively calm. So to conclude, so the protection under international humanitarian law is not substantially lower than the human rights law. So neither the opposite is correct. IHL rules applicable to occupation may be applied in an overly rigid manner, resulting in the killing of innocent people and freezing the life of population somehow. And the occupied population and embedding their evolution. The interpretation of both laws to enhance the scope of protection of civilians is extremely essential. However, there's an urgent need to study the situation case by case to be able to issue sound jurisdiction which will work in favor of protecting the civilians and would influence international protection regarding the violations that are taking place in practice. So the closer the situation is to the battlefield, the more international law will take precedence and vice versa. Therefore, in prolonged occupations, human rights law may become a special norm prevailing over humanitarian law. So it depends on the case. You cannot generalize. And the recurrent situations in times of occupation and state practices should result in not only developing a more sound jurisdiction to implement, but also reinforce the existing mechanisms that are needed to refrain countries from committing such violations. Thank you very much.
Thank you, Lama. It's interesting also the part about the derogation in emergency situation. I will have a question for you later. And now it's time to listen to the presentation of Michaela Schoschwohl, who is Deputy Director and Principal Legal Officer of the UN Relief and Works Agency for Palestine Refugees in the Near East. Michael, the floor is yours.
Thank you very much, Chair, and thanks as well, in particular to Webster University. It's a great honor to be here, actually, and to speak not only be on the panel of such distinguished speakers, but also to address you, I think. Oh, thank you. I have all kinds of electronic gadgets now, which I'm unable to operate, but I'll try. To also be in front of you, I think, who have been following this topic and conversation. So thank you for that. What I would like to do a little bit is to talk about UNRWA, to set the scene and perhaps then delve into some of the issues that already have been touched upon. And I'm grateful for, I think, my predecessors here on the bench. You have anticipated many of the issues, so you will make my task much easier, but I'd be happy to go into more detail, and maybe also in the question and answer session. But to set the scene, maybe just to draw up some parallels as well, more broadly, I mean, we all know that 70 years ago, and I think this is the theme of the conference in a way, if I understand it, 70 years ago, there was a huge push among the international community following the horrors, of course, of the Second World War, but in particular the Holocaust, to actually create a normative but also institutional structure that would address these issues, to prevent these issues from reoccurring. And that led to the establishment of the United Nations, of course. It also led to the creation of a normative structure in the form of, well, starting with the Universal Declaration of Human Rights, declared in 1948, but then subsequently instruments that were adopted. And I think one of the key instruments that are subject to the debate here is, of course, the 1949 Geneva Conventions, the 4 of them. And so we shall see how this is relevant for us. But I think there is in a way, a parallel in the sense that these structures, normative and institutional, were there to protect population from war and from suffering in different conditions. And I think the parallel is that UNRWA does very much the same. We are established by the United Nations to offer assistance and protection to one particular group, which is Palestine refugees. And when people sometimes say, I think we hear often colleagues refer to the fact that perhaps 70 years after the adoption of these instruments, they are no longer relevant, they should be changed. Our thought on this is rather, well, we work with these instruments every day. I'm working at the Department of Legal Affairs, I'm doing a lot of international law there. We use these instruments every day. The provisions are very clear often, and it's not the clarity of the provisions which is a problem. It's often, I think, which is a theme that I'm sure you have explored already, it's often the lack of enforcement that is a problem that we haven't really found good solutions for. Now, when we talk about, of course, the protection of civilians in occupation, then as we have already seen, because I think that my previous speakers have touched upon that, it's difficult to talk about prolonged or protection of civilians in occupation or under occupation without actually looking at the occupied Palestinian territory. So now is the moment when I need to find the right button. Okay, here we go. Yeah. Just maybe to start by giving you a few snapshots. And again, there will be different perspectives, legal, political, we recognize all that. But to give you a few snapshots about what UNRWA is and what it stands for when it comes to Palestine refugees, and then maybe delve a little bit into some of the issues from a more legal perspective. So we were created in 1948 by a relatively infant United Nations organization at the time. And of course, we were created in the context of the Arab-Israeli conflict. So that led to the displacement of about 750,000 Palestine refugees. And they essentially settled wherever they could. You see a picture, all of these pictures, by the way, photographs, I've learned this in terms of presentational skills. You have to somehow put background that keeps people awake, especially before lunch. So these are pictures that are taken from our archives, from the UNRWA archives. And you can see how they basically just ventured out into the open space and tried to find refuge. And they found refuge in the neighboring areas, pending what we call a just and lasting solution, which of course at the time refugees were thinking that such a solution would be just around their corners, and many after 70 years still hold the keys to the homes that they have left, whether it's in Jerusalem, Haifa or elsewhere, as a sort of symbol of the hope that they would be able at some stage to return. So they were settling essentially in open space. UNRWA was then created to address, first of all, the immediate needs that arose out of that. You have to imagine yourself, 750,000 people. You may be one of, if you are among those, you would be needing assistance because suddenly you find yourself somewhere else, completely removed from your regular context. You need relief and assistance, and there were many organizations at the time that provided that, NGOs. There was also the predecessor of UNRWA, which provided some form of coordination of this assistance, and then UNRWA was created by the General Assembly to somewhat as a program to provide specifically relief and works. And this is the part that sometimes gets forgotten, but I won't go into that, to Palestine refugees pending the solution of their plight. provide. It wasn't supposed to solve the problem. There was a different United Nations organization which was tasked with that. It was supposed to provide humanitarian assistance at the time. So if we look at then what UNRWA first of all did, and again, this is a picture, original picture taken from the registration process. Of course, you have to register your beneficiaries. So what the first step in the process was historically to register Palestine refugees and to register them according to a definition that the UN adopted at the time. Now, there were 750,000 Palestine refugees in 1948 that were displaced. They, of course, grew. And if you look at it over the years, since then, we have about 4 generations of Palestine refugees. Because the problem hasn't been resolved. It's part of the broader issues that require final status negotiations or solution. The refugee problem is among them. So there hasn't been such a solution found yet, despite various attempts. So we still have, of course, the population of refugees, as would be the case for any other protracted refugee situation. So in that sense, Palestine refugees are not unique. You have this phenomenon of, unfortunately, of protracted refugee situations in many different contexts. Think of, I don't know, Afghanistan, for example, and refugees that have fled the conflict there in other contexts. So when we were generated, or sorry, created by the General Assembly, and I think it's worth emphasizing that UNRWA is a subsidiary body of the General Assembly, we were meeting the needs of 750,000 people, and this has grown to a refugee population today of more than 5.4 million Palestine refugees. The statistics here includes other persons of concern, as perhaps UNHCR terminology would say, but we call them registered persons as well. Now, what UNRWA did, of course, initially was focusing on relief. But ironically, the Palestine refugee community itself thought after a while that actually we are also in desperate need of giving our children a perspective. And that perspective, pending the return, what they thought, would of course be also education. So Palestine refugees teachers themselves organized schools initially that UNRWA then took over as one of its core programs today. So you can see here one of those schools, obviously very improvised at the time. And now, fast forward 70 years later, we operate about 715 schools in the region. And I should say, and I should have said initially, we talk here about occupation particularly, but UNRWA operates not only in the occupied Palestinian territory, which, to be clear, for the UN encompasses the Gaza Strip, but also the West Bank, including East Jerusalem. This is based on relevant UN resolutions. But we operate also in other areas. We operate in Jordan, Syria, and Lebanon. And so we have 750 schools. They are offering primary education. We also have other installations, I won't bore you with that, that provide vocational training and some form of higher education, but it's very limited. We focus on primary education, of course, with the intention that the children can then continue their education among the communities in the host countries. Now, we don't only provide education in schools, and this is something that sometimes becomes unfortunately quite relevant. We often also use our schools, or have to use our schools, as shelters. So emergency shelters that's provided by the UN, you will find that it's not a unique phenomenon for UNRWA. It's, by the way, done by other, or in other UN contexts as well. Think about Sudan at the height of the conflict. But for us, especially in Gaza and Syria, this has been an issue where Palestinian refugees in conflict have really not found anywhere else to go. So they went for UN installations at the height of the conflict. In 2014, we had about up to, I think, 300,000 people sheltering our schools. And they went to our schools because they thought that the UN flag would protect them. In most cases it did, but unfortunately in some it did it, which cost 44 civilian Palestine refugees their lives. Now the same, by the way, in Syria, and this is one of the pictures taken in Syria. What else do? We provide relief. I mentioned that in the beginning in terms of setting the scene of how it all evolved. Relief is a huge component for us. Of our Palestine refugee population, we have about 1.2 million who live in absolute poverty. and 700,000 in abject poverty. And the result, or the reasons for that are manifold, of course. But one element that's key is that Palestine refugees often have been displaced on multiple occasions. Not only once in 1948, but then in 67 perhaps. You have other episodes of conflict. Think about you a Palestine refugee who had moved from Gaza to Jordan, from Jordan to at some stage to Syria, and then 2011 the conflict starts again and you are moving from Syria to Lebanon or Jordan back in a context where the governments are not necessarily very receptive to your presence. So that's, of course, generates additional vulnerabilities, and we are trying, as the UN, to meet them. Another factor that I should perhaps just mention as an aside is that we don't only provide relief, we also maintain records. We have archives and registration records that may hopefully one day be useful for the finding of a solution. Now, just quickly to mention another key area of our work is, and including for Palestine refugees under occupation, is the provision of health services. So we run primary health care facilities, about 140. We have annual services provided to about 3.1 million Palestinian refugees. So you see that many refugees still rely heavily on UNRWA services, and there are all kinds of facets to that which I won't go into. Now, this is significant when you look at it from a perspective of human rights and international law, because in a way, UNRWA and the United Nations, well, meets human rights needs. We meet the right to education, we meet the right to health, adequate standards of living. These are all human rights that are in the International Covenant on Economic, Social, Cultural Rights. I should mention in this context that we do, of course, more in terms of human rights work, international law work more broadly, and that is, we also, of course, highlight the human rights situation and deficits that Palestinian refugees will experience vis-à-vis relevant human rights mechanisms. Now, these deficits, maybe just quickly, I'm not sure how much time I actually have, maybe just for the chair to advise me. 5 minutes, okay, excellent. Thank you. So these deficits are quite visible, and I think my predecessors here have, previous speakers, have touched on them. Now, just to give you a bit, maybe a summary of it with some legal remarks, in the West Bank, it's quite clear. We have seen the separation barrier. Now I've lost track of my slides, which is always great. We have the West Bank barrier or wall that has been the subject of International Court of Justice advisory opinion, so I won't need to dwell go into that. It, of course, has a tremendous impact on the freedom of movement of individuals. It comes with a regime, with a permit regime that's associated with it. And as I think, well, the distinguished Yunus Al-Khatib has already mentioned, to the extent that the wall is built within the occupied Palestinian territory is considered to be illegal under international law. That's not what I said, but that's what the International Court of Justice has pronounced itself on. Now, the other feature that comes, of course, when you look at the West Bank with the different developments is the construction of settlements. You have more than 500,000 settlers living in the West Bank. From an international humanitarian law perspective, it's quite clear. It's a prohibition of the construction of such settlements. It's built, well, this is based on the one hand on Article 49 of the Geneva Convention, where the occupied powers shouldn't transfer the parts of the occupying population into the occupied territory, but also is attached to the broader prohibition of the taking of land or property by force, annexation and so forth, and the creation of a fait accompli or facts on the ground that sort of further the annexation. So that was the rationale that the International Court of Justice pronounced itself on, and I think this is based not again on what the UN as a UN agency says, but more what the Security Council, for example, has held quite authoritatively. So it's in that sense is very well established. There are other features that you will encounter in relation to construction and construction permits, particularly in Area C, and associated consequences. I think Al-Khatib has already mentioned the problem that most Palestinians are not able to lawfully build in Area C in particular. That has had all kinds of consequences in terms of demolition orders, evictions. We have communities in Area C, in particular the Bedouin community, who are largely Palestinian refugees, who are under threat of being what's prohibited under international law as forcible transfer, again, Article 49. We have other issues that, of course, feature in our daily work, including punitive demolitions. I will not dwell in that area, but it's something that borders or has been recognized as being a form of collective punishment and hence declared illegal under international law. That's one set of issues in the West Bank. And then there's another set of issues I think that you have already talked about, and I think both of you actually, in terms of the use of force. And the use of force not only in relation to the West Bank, but obviously also in relation to the Gaza, and the legal analysis that applies to that. I mean, we as UNRWA, we have monitored this quite carefully, also in relation to the West Bank, where we look at incidents of Palestine refugees and Palestinians being killed in the context or around what's called search and arrest operations of the Israeli forces, security forces, often coming into Palestinian refugee camps for various reasons. This sets off or is accompanied by all kinds of developments, usually also riots or protests, and that will often lead to the use of lethal force. And we as the UN, we've expressed concerns about the use of lethal force in these kind of contexts, precisely because of, oh, thank you, there's the time, excellent, thank you. Precisely because of what you have mentioned here before about the different interplay of the legal regimes that apply. And I think it's important just to highlight and underscore that even though it's an occupation and the laws of arms conflict apply, this is the law of occupation is in the context of law and armed conflict, it's recognized that even in that context there is a responsibility even of the occupied power to ensure law and order, of course. And that is removed from the hostilities. That is an obligation to also comply with what's called the law enforcement paradigm. So when the occupied power ensures law and order, there are standards that would apply. These standards are usually informed by international human rights law. They're quite strict because, in contrast to international humanitarian law, it's not all about killing. That's what international humanitarian law facilitates in a way. It's about preserving life, the right to life, or the prohibition of the arbitrary deprivation of life, an essential fundamental human right under Article 6. It's possible for the police or any law enforcement authority around the world to kill, of course, in the context of law enforcement, but only under very strict conditions. And these are around proportionality, necessity, there needs to be an immediate threat to one's life, and so forth. It's somewhat similar to international humanitarian law and the principles that apply. So in the context of occupation, where there are no armed hostilities, this law enforcement paradigm will apply, and we will apply it as lawyers in looking at legality of different acts. And this applies both to the West Bank and also Gaza, by the way, which I won't have time to go into in much detail. Maybe just to say in relation to Gaza, of course, let's see. One of the issues here is, of course, the blockade. You can, again, have different perspectives about it. From a legal perspective, there's, of course, the international humanitarian law perspective and the various obligations in relation to, again, collective punishment and so forth. You also have the human rights perspective and what the blockade, what we call as UN, the blockade does in terms of the enjoyment of the rights to health, education, adequate standard of living. This is a picture of a student trying to study at night amidst obviously regular electricity shortcuts. So this is the situation that you will face as a Palestine refugee child in Gaza, or a Palestinian more broadly in Gaza under the blockade. Now, I recognize that I'm running out of time. One area that I haven't touched on, but I would be happy to expand on, is an area of international law that's quite significant for us as well, and that is about international refugee law and how it applies to Palestine refugees, the status, and the various arguments around that. Just to note that this is, of course, of tremendous importance. There is a specific regime that the international refugee law in the form of the 51 Convention, which has been born around the same time as the 1949 Geneva Conventions, provides for. Now, just to conclude, perhaps, to say that I think, as you can see, perhaps, hopefully, all of these issues have legal dimensions that we focus on in our work. And as I said in my introductory remarks, both perhaps UNRWA and also the international humanitarian law regime and the human rights regime were all born in a hope that this would be quite temporary in terms of needs. Everybody thought that you introduce norms and then prevent or will anticipate that in the future these kind of conduct will be banned from humankind's existence. Unfortunately, it has proven that both, I think, IHL, human rights, but also UNRWA, we continue to be in existence and in need, and I think I very much would hope that one day this would no longer be the case. With that, I will hand over to you, Chair. Thank you.
Thank you, Michael.